Okay, we are good to go.
Okay. Good evening. My name is Jay Wetter, Vice Chair of the committee. This is a regular meeting of the Planning Advisory Committee for the date December 19th, 2023. As we gather, we recognize that we are on Treaty 3 lands, which are steeped in rich Indigenous history and home to many First Nations and Métis people today. We continue to be thankful for the partnerships with Indigenous people. We give thanks for the many blessings we enjoy in the city of Kenora. We seek wisdom in our minds, clearness in our thinking, truth in our speaking, and always love in our hearts. Let these principles guide us in our decision-making. Prior to calling the meeting to order, please ensure your microphone is on mute and please be mindful of what is visible to the public in your surroundings. Please note this meeting is being recorded, and by continuing to be in the meeting, you are consenting to be recorded. Tap leave meeting to opt out and exit the session. When it is time for public comments, I will address the participant by name, by the name that was used to register for this virtual PAC meeting. Once your name has been called, please then unmute your microphone or your telephone. All persons addressing the committee shall state their full name and mailing address and must direct their comments through myself, the chair. Decisions will be mailed or emailed to the applicant, agent, and to all other interested parties who have provided their mailing address and or email address to the Secretary Treasurer. Recent changes made by the Province of Ontario Bill 23, More Homes Built Faster Act, have changed who has the right to appeal decisions made by the Planning Advisory Committee. Other than the applicant, only a specified person or a public body, as defined in Section 1(1) of the Planning Act, has the ability to appeal the decision to the Ontario Land Tribunal. The notice of appeal for a minor variance application must be filled with the Secretary Treasurer within 20 days of the making of the decision. The notice of appeal for a land division application must be filed with the Secretary Treasurer within 20 days of the mailing of the notice. Secretary Treasurer for the Kenora Planning Advisory Committee is Melissa Shaw. At least that's what it says on my notes here. Is that still correct?
My name is Ulrich Marchand.
I have you down as the Associate Planner here. Okay, so Secretary Treasurer for the Kenora Planning Advisory Committee is Albrecht Marginet. The City Planner is Kevin Sumner. All right, I will call the meeting to order. Any additions to the agenda?
Yes, Mr. Chair, we will be having a brief discussion about the responsibilities of open houses that will occur between the consideration for applications for minor variance and the recommendations to council for zoning bylaw and official planning permits.
You bet. Thanks, Albert. I'll try to remember that. If I don't, please let me know.
Absolutely, Mr. Chair.
All right. Any declarations of interest by a member for this meeting or at a meeting at which the member was not present? Any declarations of interest?
Myself concerning the meeting minutes for October, considering I was not a member at the time.
You bet. Thanks, Chris. Right. So on that note, we will have approval of the minutes. We have minutes from two meetings, October 17th and November 16th, for approval today. We'll do them one by one. Any comments on the minutes for October 17th?
We received comments from members of PAC committee for amendments to both sets of minutes. Mr. Chair, I believe our minute taker has already made those corrections.
Okay.
From the ones received from Vice Chair Wetter, right?
Yeah.
Okay.
Yeah,
Yes,
exactly.
I've added those changes.
Okay, good. Thanks. Anything else?
I have no other indication.
We
of
need
requirement.
motions to accept the minutes.
We do, yes.
Okay. Can I get a motion to accept the October 17th minutes? Robert Bowman, seconder, Renee Romero, and all in favor? And you're abstaining. Yeah, good. One abstention noted there. November 16th minutes. Any changes to those?
Aside from the changes which you have provided to the planning staff, there were no additional changes, Mr. Chair.
Anybody else notice anything?
No,
Okay.
but I'll move.
You'll move, okay, move. Second,
No, my declaration wasn't noted in the November minutes, even though
Okay,
the meeting minutes for October were not
okay.
passed, they were moved on to this month.
So do you want to clarify that for Alan?
So my declaration wasn't put in the previous minutes,
Okay,
The November minutes.
correct?
Yeah, that was your meeting.
Yeah.
Okay.
And then I'm curious about the format. There was discussion by yourself concerning one of the applications, but that wasn't noted. Is that in your,
No, so we've stopped noting specific comments and we just note that there were comments, but we don't specify the comments. Is that?
If there are points of discussion that you feel need to be recorded in the minutes, you need to state that. A summary of what that point is, but we're not having a verbatim record of the discussion. So just if you feel that there is a point that needs to be reflected, then that would be noted to the minute taker at the time of the discussion.
got you.
Is your motion still
I
standing?
will move to accept the minutes for November.
60, yeah. Second? Okay, all in favor? Opposed? All right, any correspondence relating to applications before the committee?
All correspondence that has been received by the planning department has been submitted to the members of the planning advisory committee, and was accessible on SharePoint as of Friday of last week.
Okay, nothing new to add. Okay, and we will get to those as we talk through the files. Any other correspondence?
There has been no additional correspondence, Mr. Chair.
All right, we'll move on to file D132319 Ross, which is, well, actually, that's an adjournment request, because this is on there twice. But what's happening with that one, Secretary Treasurer?
We've been waiting to receive information for the Ross application. We still have not received that required information. We are making a request to adjourn this hearing again.
Okay,
I will add that we have seen progress since the last meeting, so this isn't sitting in limbo. There's a surveyor engaged that's providing some necessary information, and that's just taken a little bit of time to get together. So we are optimistic that this will be coming to the committee. Well, yeah, I'm not sure if we'll get it soon enough to get it to next month, but I'd say February, there's a good chance.
okay, thanks, Kevon. All right, now we'll move on to considerations of application for.
Oh, Mr. Chair, we need to make a vote on whether or not
To accept.
we're accepting
The adjournment?
the
Okay,
adjournment.
good, thanks for that. Alex, was that your point as well? Okay, all right, do we need a mover and a seconder, like
Yes,
the full on
please.
vote?
Yes.
Okay, could I add a mover to adjourn file D132319 Ross?
Yep.
Renee, seconder?
Yeah.
All in favor? Okay, carried, great. So that means as we move on to considerations of applications for minor variance, we will scratch Ross off that.
Correct, yes.
Okay, my agenda still has it there. And by the way, if you're on the remote hybrid version, and if I stare off into space, it's because I'm looking up at you at the screen. So that's why I'm looking off into the sky every once in a while. All right, file D132320 Hidden Trail, and I know we have someone from Hidden Trail here today. And so the representative from Hidden Trail, this is your time to speak to the file if you'd like to.
Yes, good evening. It's Karen Malik here. We've put in this application for a minor variance subsequent to our application for a consent, which was approved at the last meeting.
No,
October meeting, pardon me. So yeah, we're just here to answer any questions that may come up, but we'll just let the process flow the way it should. Thank you.
Could you please give your name and address?
name and spelling.
Absolutely. Pardon me?
Yeah, spelling, sorry, pardon me, the spelling of your name, just for our record keeping.
Okay, so first name is Karen, Karen, last name Malik, Malak. And address is 162 Hidden Trail.
Don't need
don't
the
need that?
address, actually,
Okay.
just the proper spelling of the name. Thanks,
Okay.
Karen.
Okay, thank you.
All right, the city staff, Kevon, is that you presenting the planning report?
Yep, it is. And I'll keep this relatively concise. Normally, when we have a consent and an associated minor variance, we bring it forward at the same time. Unfortunately, with this one, we didn't catch the need for the minor variance in time until the consent was well underway. So that's why it's coming forward separately. And I think all but one committee member have heard a lot of the details of this property previously, so I'll keep it fairly succinct. The consent was approved in October. One of the conditions on that consent was that there be a minor variance for the minimum required waterfront frontage on the proposed lots 1 and 2. If you're looking for my report, you can see the location of those two lots illustrated on the report, and you can see the frontage where the frontage on Black Sturgeon is located at the southern edge of those two proposed lots, and they're just slightly less than the minimum required frontage, which was 61 meters. They're at 55.2 meters and 60.2 meters. Because they are being newly created, and actually historically there were two lots that had those exact same frontages there. One lot which exactly corresponds to proposed lot 1, and another lot which made up about the western half of proposed lot 2. Those lots became consolidated at some point in the past and had to be resevered. So that's why we had that consent, and you heard all about that when I delivered my report back in October. I don't see any need to go into a whole length about the official plan and zoning for the property, since we discussed it back in October. In terms of the 4 tests, does it conform to the general intent of the official plan? Yes, in allowing for the creation of lots that are supported by the official plan. Does it conform to the general intent of the zoning bylaw? Yes, the proposed relief does not appear likely to impact on any neighboring properties, and the reduced frontages correspond to the historical frontages. If they hadn't been consolidated, they'd be just existing lots of record. Is the application desirable to appropriate development of land? Third test. In approving the associated consent, I noted the Planning Advisory Committee has deemed the lot creation to be desirable, including the need for this variance. And finally, is the proposed variance minor in nature? Yes, I believe it is, as it's the minimum relief required to accommodate those frontages. My evaluation is that there's no concerns of being identified, and that this will fulfill the condition for final approval of the associated consent, or one of the conditions. So I'm recommending that the committee takes into regard any written and oral submissions received from the public, including any comments that may be yet be received, and that the application D13-23-20 seek relief from the City of Kenora zoning bylaw 101-2015, section 4.5.3L, to allow for lots to be created with minimum frontages of 55.2 meters and 60.2 meters, meets the 4 tests and should be approved. Thank you.
All right, thank you, Kevin. Karen Malik, any further comments?
None from me. I think that pretty much sums it up. Thank you.
Do we have public comments either in support or opposition? Okay, I think we do this in order. Anyone from the public want to speak in support of this application?
I see no one, Mr. Chair.
Anyone from the public want to speak in opposition to this application?
I see no one, Mr. Chair.
Okay. Committee questions?
Nope.
All right, Secretary Treasurer, you can read the motion.
All right, decision being that the application D13-23-20 to seek relief from the City of Kenora zoning bylaw 101-2015, section 4.5.3L, to allow for lots to be created with minimum frontages of 55.2 meters and 60.2 meters, meets the 4 tests and should be approved.
Any final discussion? I need a mover. Chris, seconder, Renee, all in favor? Any opposed? carried. All right, Albert, back to you to advise of the appeal period. Any other notes you have to say on that?
All right, thank you, Ms. Malik, for joining us here this evening. You have received approval from the Planning Advisory Committee. However, this is subject to a 20-day appeal period, which will end, it's the 19th today. This will end on January 8th. You will receive notice by email when this period has passed. If you have any questions, please feel free to contact me. This, of course, is subject to the conditions set in the planning report.
Thank you. Next item on the agenda is the added item. Albrecht, you're going to talk to us about rules for discussion with regard to the open house, etc.
Yes, I believe that the planning director, Janice Pacillo, has comments she would like to make regarding the process of the open house for planning and for zoning amendments.
Okay.
We just wanted to clarify the role of PAC in zoning and official plan amendment applications. So in both, PAC's responsibility is to make a recommendation to council, but we typically use the PAC meeting as well to hold a public open house. Now for the application that you just did for a variance was a statutory public hearing where people come in and speak for and against an application, whereas an open house is slightly different. Members of the public can come and ask questions as well as share information. So it's just that subtle difference. We have been holding them very much in the same manner, that people come in and make presentation. Where that's true, we're here to receive information, but we're also here to disseminate information. So if members of the public do come in with questions and ask and just want to hear the proceedings, that is all right as well. So I just wanted to take a moment to sort of talk about that and understand the difference between an open house and a public hearing. And there may be instances where it is advisable for the department to hold the open house in a different format, maybe a more traditional format where separate from the PAC meeting, that people can come and learn about different amendments. So when we're doing the meeting, we can be a little more casual in our discussion and asking questions and sharing information.
And the committee can participate in discussion, correct? This isn't just a public open house?
The committee, I think, can also participate in the discussion.
Ready to proceed?
We are,
Okay.
Mr. Chair.
All right, we'll move on to considerations of application for land. Oh, pardon me. We have none of those. We'll move on to recommendations to council for zoning bylaw and official plan amendment. We just talked about the official plan amendment, but first on the agenda is file D14-2311 White. And so that's the file. Anybody from this file going to speak to it? Representative or landowner?
The landowner does not appear to be with us in this meeting this evening.
Okay, good. Thanks. So. Okay, so Kavan, it goes to you to read your report.
Yeah, certainly. So, yeah, what we're considering here is an application for zoning amendment for a property. It's unaddressed. If you're looking to the map that's provided with my report, you can see it's located just north of the CPR rail yard and a little to the west of 13th Avenue North. And the current zoning of the property is a combination of RU or rural zone and R1 or residential first density zone. Again, if you're looking to that map, the blue area, blue outlined area in the map is the area is currently zoned RU, and the red outlined lot is currently zoned R1. And the proposed amendment would change the zoning of that entire property to R3 or residential third density zone. The reason for this is that the owner and applicant is proposing to develop the property with 4 separate 4-unit dwellings for a total of 16 units. This is considered a moderate density development, and what we consider moderate density is anything other than under 40 units per net hectare. And the applicant also has submitted a noise study addressing the proximity to the CP rail yards. So the property at present has an area of approximately 6,800 square meters, located north of the rail yard, with access from 13th Avenue North via a currently unopened and undeveloped street right of way. So where you see in the site plan submitted by the applicant that they have the road coming into the property, that is across a municipal right of way. It's never been opened or developed as a street. The property has been mostly cleared and slopes upward to the north, as you can see in the image or the photo that I took and submitted with my report. You can see the photo there taken from the southeast corner of the property. Turning to legislate policy and city directives. First of all, the provincial policy statement, or PPS 2020. The PPS encourages redevelopment within settlement areas with a mix of land uses that efficiently use land and resources, are appropriate for and efficiently use available infrastructure and support redevelopment. The PPS also encourages an appropriate range and mix of housing options and densities to meet projected requirements for current and future residents, by permitting and facilitating all housing options required to meet their social, health, economic, and well-being requirements. Directing the development of new housing towards locations where appropriate levels of infrastructure and public service facilities are available, and promoting a density that efficiently uses the land. Now, in terms of the growth plan for Northern Ontario, we are satisfied the proposed zoning amendment is consistent with policies of that plan. And then the City of Kenora official plan. So this entire area, these subject properties and the area surrounding them are designated as established area. Residential development is to be encouraged, and medium density residential use is supported, provided the development is in keeping with the character of the area. Minor changes in land use that are compatible with existing land uses and do not result in significant increases to traffic, dust, odor, or noise, that are similar in scale to the surrounding built form and that improve the quality of life for area residents, may be permitted through an amendment to the zoning bylaw, such as we have here. Now, as I mentioned previously, there's a CPR rail yard to the south of this property, and it's designated as rail yard under the plan. Noise study is required for any residential development within 1,000 meters of the rail yard, and we may require a noise and vibration study for developments within 75 meters. And the official plan discourages new residential development within 300 meters of a rail yard, but allows for limited infill on existing lots of record, such as these are. Under the City of Kenora zoning bylaw, the property is currently zoned RU and R1. The proposed R3 zoning will allow for the development of a full range of housing forms and other compatible uses serviced by municipal sewer and water. And I do note, and I'll get back to this in a couple of minutes here, we do have a section 3.13.1 of the zoning bylaw, which states that no more than one dwelling can be erected on any lot. This regulation will affect the development as proposed, and I'll discuss that in a minute here. In terms of interdepartmental and agency circulation, we did send this out for external comment. There is no comments or concerns from any external agency or entity except for the Saskatchewan Anishinaabe Nation. And they wrote that they acknowledge the importance of this proposal in meeting housing needs of the city. However, they note their sacred law, the Manitowoc Inakanagawin, sorry for my pronunciation, must be recognized and observed as part of the approvals process. Their preliminary review indicates that the proposed development is within the vicinity of traditional resources that hold contemporary and historical significance, such as but not limited to hunting and trapping grounds, manure harvesting, and culturally significant sites. To properly understand how the proposed development will impact their inherent and treaty rights, further consultation with their elders and knowledge keepers is required. They note that as Treaty 3 Anishinaabe, They are guided and bound by their sacred law, the Manitoaki and Nakagawan. That law requires proponents to consult with their elders and knowledge keepers to identify potential impacts, require mitigation efforts, and establish appropriate ceremonial protocols. In addition to the requirements of that law, the following questions have been raised, and they put the series of 3 questions to the city, asking first, have any studies been undertaken to identify current and historical resources used by Anishinaabe? Please comment on uses pertaining specifically to culturally significant sites, berry harvesting, and manoomin, including impacts to these uses and identified mitigation measures. 2, how the proposed amendment, development, and subsequent activities result from the proposal impact their ability and capacity to entertain their Aboriginal and treaty rights to engage in traditional land use. And 3, how does or can this development process aim to respect the Manitoaki and Nakagawan process and application framework? Is there a way to collaborate moving forward? They further note they believe that consultation on these matters to understand how the conduct communicated in your notifications may impact our Aboriginal and treaty rights, and if applicable, discuss ways in which the City of Kenora and Grand Council Treaty 3's development approaches and process may be harmonized to reasonably accommodate their Aboriginal and treaty rights, nation concerns, and interests. A decision by the City of Kenora to approve this application without consultation will be considered a violation of the Manitoaki and Nakagawan and our constitutionally protected rights. There was no other concerns identified, including by municipal departments. So the council will be holding their statutory public meeting on January 9th of 2024. Notice of the application was given in accordance of Section 34 of the Planning Act. The minutes and relevant resolutions from this Planning Advisory Committee meeting will be forwarded to council for their information when they consider that application. As of the date of this report, 1 letter of objection was all received from the public and was attached and included in the SharePoint files. That letter pointed out an error in the public notice regarding the deadline dates for submission of comments and expressed concerns that the width of 13th Avenue is insufficient to support additional development, and they questioned whether development will affect nearby marshlands and swamps or the pond at the end of Preston Street. A corrected notice was mailed out to neighboring property owners, and a correction is being placed in the municipal memo in regarding to the errors in the notice. The original notice contained the correct meeting dates, but an incorrect deadline for submission of comments. It accidentally said November instead of December. So my evaluation is that the PPS, the growth plan for Northern Ontario, and the official plan are supportive of the zoning amendment. The R3 zone supports a full range of housing types, including the proposed multiple attached dwellings. Due to density restrictions in the established area designation, development is limited to a medium density, which the development achieves. The applicants have provided a noise impact study, which concluded that the implementation of recommended noise control measures and warning clauses, the noise impacts from rail traffic sources will meet guideline limits outlined in the MECP's NPC 300 guidelines and Canadian Pacific Railways requirements. On reviewing the property and determining that while the CPR property is located only a few meters away, the closest rail line is at least 105 meters from the closest point of the subject property. So the planning department determined that a vibration study would not be required for this development. So if you remember, the official plan speaks to a need for a vibration study within 75 meters. But in this case, there's a big part of the CP property that doesn't contain any rails or activity south of this property, creating quite a significant buffer. A neighboring property owner has, as I noted earlier, expressed concerns regarding 13th Avenue. The internal municipal review has identified no concerns regarding the impact on local roads. Drainage of the property will be considered via the site plan control approval process with the benefit of more detailed plans at that time. Other detailed plans such as road access and municipal servicing will also be reviewed during site plan control. In reviewing the site plan submitted with the application, the planning department has identified a potential issue with proposed development, being that it contains 4 separate 4-unit dwellings. The zoning bylaws section 3.13.1 residential law occupancy currently restricts more than 1 dwelling from being on a single property. An amendment to that section of the bylaw is being proposed under the next application we're going to be considering tonight or hearing about, the city's housekeeping bylaw. If that bylaw passes as proposed, the project will be compliant with the new regulations, but with consideration of the possibility that bylaw could be delayed for unforeseen reasons, the committee may wish to recommend that this zoning amendment contain a site-specific exception allowing for multiple attached dwellings to be located on the property, just to give the applicant peace of mind. In consideration of the comments that we received late last week from neighboring First Nation, my recommendation as the city planner is that the application for zoning bylaw amendment file number D14-23-11 to change the zoning of the subject property from RU and R1 to R3 sorry, I think there's incorrect version of a report got uploaded here. Actually, my recommendation is that a recommendation for approval cannot be given at this time in light of those comments that were provided. But if the committee should choose to recommend this for approval to council, I would recommend that the committee recommend that the proposed development be amended to add a site-specific exception for the subject property, permitting the construction of 4 multiple attached dwellings on a single property. With that, I conclude my report. Sorry for that stumble there.
Yeah, no problem. Thanks, Kavan. Still nobody from the file, landowner or agent to comment?
No, Mr. Chair.
Okay. Anyone from the public want to speak in support of this application? Doesn't look like we have anybody, right?
It doesn't appear we have anyone, Mr. Chair.
Okay. Anybody from the public want to speak in opposition of this application?
I see no one,
Same.
Mr. Chair.
Okay. Committee, questions? Alex, did you have one?
It was only one letter received in opposition, just confirming for the notes,
2 letters.
2 letters. Thank you.
Any other comments, questions?
So, more comment, I guess, than a question. The comments from the First Nations, so I guess it is a question. So there's no requirement then by the applicant to approach the First Nations and to initiate consultations in order to address some of those concerns.
Yeah.
So
that is a request that's being made by the First Nation. We can only require as a city any actions or reports or studies that are in our policies to require. That's our current policies haven't envisioned or anticipated requests such as these. This is something that maybe need to be considered as the city develops its new official plan. But for now, the request that I read in that letter submitted by the First Nation is a request directly from that First Nation and not a policy of the city of Kenora.
So the city has notified First Nations and fulfilled our responsibilities under the Planning Act to invite comment, and they have responded with concern, feeling that additional consultation would be required under their law. We have met our requirements, and we also have requirements to make a decision within a certain period of time. So it is something that's very difficult. We would like to work more closely with our First Nations neighbors and avoid situations where we're forced to make a decision with less information than is ideal. In this case, we did not ask for an archaeological study. So all we know about this property is that it was part of the original railway subdivision. We have no knowledge of what the land was used for prior to that. It is a greenfield site. We don't have any knowledge of it being used. Correct me if I'm misspeaking, but no information of it being used since it was subdivided by the railway 100 years or so ago. We have no knowledge of harvest, wild rice or trapping, and that information has not been provided in the letter from the First Nation community either. So we're at a situation where we don't have additional information.
Yeah, if there is additional information that comes to light before the statutory public meeting of council in January, I referenced in my report the provincial policy statement that requires planning authorities, in this case, the City of Kenora Council, making a decision on the zoning amendment to consider the interests of First Nations. But ultimately, if there's more information, we'll certainly put that before council, but council will need to weigh any the concerns of the First Nation with all other matters that they have to consider in whether or not to approve the amendment.
So we cannot approve this conditional on getting that work done then?
You're making a recommendation to council. So you're not, and Janice touched on this before we got into the zoning amendments. You have a fair amount of leeway in terms of what you recommend to council. I'm suggesting, and this is the same suggestion I made when we heard similar concerns on the Edge Corp zoning amendment and official plan amendment back in August. I'm suggesting that the committee state that they can't recommend approval at this time, just in light of the late concerns that were raised. That's my professional recommendation. You can consider that. But if there's anything else you want to make a point of in your recommendation to council, you're certainly free to do so.
Is the Edge Corp, was that the Villeneuve Road?
That was Duncan Farms property, Mr. Chair.
The Rabbit Lake one.
We approve that one.
Rabbit Lake Road. Okay, right. I mean, this is greenfield, but it's cleared land. So something has been done with it before.
Yeah, my understanding is the previous owner of the property approximately 4 or 5 years ago cleared it in anticipation of development, and then the current owner purchased it after that point. I know it was, I think it was somewhere around 2018 that it was 2018 or 2019 that got cleared.
Thinking unless there's an environmental assessment on file somewhere, which it sounds like there isn't, that would appease the First Nations interests, then yeah, I can't approve it. Yeah, that's my thought.
Just a note, Mr. Chair, you're not approving this, you're simply making a recommendation to council on it.
Right.
Hmm.
Can we approve it with conditions so that it doesn't have to come back to us?
To put that in recommendation terminology, you may want, you could say, I don't mean to put words in your mouth, that recommend that an archaeological assessment be completed prior to council making a decision on the proposed amendment.
Yeah.
Any discussion?
Be satisfied. I mean, I'd be satisfied with that. It's just one condition before we can go for approval versus turning it down.
Yeah.
There's also the site-specific bylaw as well, if you want to add that into your motion.
Yeah, so if we're going to move it forward, we will add that site-specific exception.
Kevin, cabana. Would
Yep.
the archaeological identify the natural resources that are identified in Saskatchewan's concerns? Like the monument, I don't think that would fall under that, would it?
I can't, I don't want to speak for Saskatchewan. You know,
No, I'm
they,
just saying, no,
It
The-
would not, it
okay,
would
yeah.
identify cultural resources.
resources, yeah,
Um.
it wouldn't identify natural
Mon-
resources.
Monument is wild rice harvesting, it would not.
Right.
Touch on something like that unless there were. Artifacts or. You know, if it was a traditional wildlife harvesting area, then that might come up. But it would not speak specifically whether or not there were wild rice plants here.
I
Would we-
would note that this is privately owned property and has been for at least some period of time, so if there was traditional any activities on the property would, I would think would require the permission of the current or the previous property owner anyways.
Just to clarify, Kevin, on your point about the archaeological assessment. I mean, is that a step too far? Like, I think the First Nation would just like consultation. Would it? Or-
Yeah, again, I hate to sound like a bit of a broken record, I think this is just, this is sort of an evolving landscape and we have at best an incomplete understanding of the wants and desires of Saskatchewan in terms of how and of their concerns and how those concerns might be mitigated. So that's why I was a bit hesitant to endorse an archaeological assessment as as the solution. It doesn't quite match with what I seem to be reading in the comments. But a dialogue between the property owner and the First Nation might help and might remedy some of those concerns. But we can't, we can certainly suggest it, and we passed on that letter to the property owner and developer. But we don't know if they're following up on it.
And we can't require that type of consultation.
Okay,
You can just recommend it.
We can recommend it. Up until this application and the Duncan Farm one as well, most of the applications that we've had, First Nation concerns, were on the river systems or the lake. So this was a divergent. So generally speaking, when we have an application come into our office that's certainly involving the Winnipeg River, the Black Sturgeon Lake, we do recommend that they reach out to our First Nation neighbors and make an attempt at communication. This is relatively new for us, that it seems to be that this is a property well within city limits. It is.
And it's not adjacent to a First Nations.
It is. It is within First Nation territorial lands, as all of the city of Kenora is, but it's privately owned land well within our borders, and it has been, in the subdivided area of town for 100 years. So it was not expected that there would be a concern, but there has been.
If I may make a suggestion, the comments that we received from the Saskatchewan Anishinaabe state an interest in traditional uses, but it appears to be more focused on the ecological aspects, perhaps requesting for an ecological study of flora and fauna on site. May be a more suitable request, given the concerns that have been brought forward.
But, and that's a valid comment. But before assuming that that's what the path they would like to see. Maybe just a conversation with them. Suggesting that to see if that would satisfy some of the questions that they've raised.
Absolutely, and I'm merely providing speculation and suggestion.
I kind of have a process question.
Yeah.
If anything we do with them for the First Nations, other than saying, you know, you should talk to them, the First Nations have both in this one and the Duncan Farms one had listed if you wish to consult with us, we're going to charge you X, Y, and Z. Can we as a committee make a recommendation based on something that the landowner would have to pay for?
As a department, we can recommend that they reach out to our First Nations neighbors if our First Nations neighbors refuse to communicate with them unless they provide them with remuneration. That would be their decision on whether to proceed with that, and it would be ultimately up to them to come to council and say, yes, we reached out. We did not pay, or we did pay, or we have comments from them, or we don't have comments from them. And then it would be up to council to make the decision whether the action of reaching out to the First Nations was sufficient to meet the requirements for consultation, or if in council's opinion, they should have gone further or not.
Can we keep the recommendation as simple as possible and say, reach out to the Saskatchewan Anishinaabe First Nation? I mean, would that be enough? Chris? Yes.
That's what I was thinking, along the lines of keeping it simple, that we can't make a recommendation to council based on the feedback we got from the Szechuan.
I think the issue based on the letter is that
How?
there wasn't enough time
Yeah.
for this consultation to happen. I mean, it was more detailed than that, obviously,
Mhm.
but I feel like if there was that gesture, that might be enough to at least have that conversation, maybe enough from our perspective, and leave it there.
And that's the extent of our authority anyway,
Yeah.
is to recommend. To council or to the applicant that they reach out.
Robert, anything?
I'm trying to remember the Duncan Farms thing because it was
Do you
similar.
have it? Can you bring it up for us, or can we use the same
Like,
language?
we didn't have this long discussion.
No.
about
With
that. It
the
seemed to-
Duncan Farms property recommended approval.
Duncan Farms was the 200 or 300 residential
Yeah,
unit
right.
development.
On another sort of similar piece of property.
Yes, the committee did recommend.
Yeah, then the committee recommended approval to city council.
no
And one of the
conditions.
First Nations did speak out against that one too.
Correct, yes.
Two did at that time.
This is not different. This is
Okay.
very simple.
So thanks for clarifying that, Robert. So we could proceed with no recommendation.
Correct, yes.
Okay. And then just add this, as Alex noted, that the committee recommends a site-specific exception from regulation 313(1) to permit 4 separate 4-unit dwellings on a single lot. Can
That's,
we add that?
that's correct, Mr. Chair.
Okay, so are we in favor? Oh, I guess we need to vote, but are you writing the motion or am I? I haven't been, but you've got a decision. Can we add that to the decision? Or the note?
Motion of approval.
I merely have the draft
All right.
decision of approval, and I was unsure what decision you would make with
Right.
this file.
Does it include each of the?
It does not.
The PAC committee recommends the approval of the amendment with a site-specific
Exception.
Yeah, do you want me to read that out for you?
exception.
Sorry, just before we get any further down that path, what were you thinking would be the site-specific exception?
As you recommended, Kevin, for the,
Four
allowing for
separate-
units on this property.
Oh, okay, sorry, yeah, okay, sorry, I thought it was related to the, yeah, sorry.
Okay. The PAC committee recommends the approval of bylaw amendment with the site. And suggests a site-specific exception of 3.13.1 for
To permit
to permit. sorry,
four separate 4-unit dwellings on a single lot.
4 separate 4-unit
Dwellings on a single lot.
on a single. You're getting this too, right, Albert?
Yes,
Oh, good.
All right, so we have a motion to approve. Do I have a mover? Seconder, Robert,
all right,
hang
so,
on, I need to vote.
oh, yes.
All in favor? Anyone opposed?
Yeah.
Yes, one opposition? Okay. 3-1, note the opposition, carried.
All right, though the applicant is not here, they have received a recommendation for approval to city council with zoning bylaw site-specific exception of section 3.13.1 to permit 4 separate 4-unit dwellings on a single residential lot for this zoning bylaw amendment. Decision will be made by council at their first regular meeting in January, on January 16th.
Okay, that's the motion. And pass the motion. And have you advised of the appeal period, Albert? Is that what you just did?
The appeal period will come after council makes its decision.
Okay. All right, that's the end of that file. Thanks, everybody.
Can I just make one comment on
Yeah.
that? If this type of letter coming from a First Nations community, we had it for Duncan Farm, we're gonna get it on this one. We're probably going to get these consistently.
Mhm.
So we're gonna have to make a decision, I think, whether we want to be consistent in what our response is going to be, or what different conditions are going to arise that where we don't approve based on some of this input.
We need precedent.
Because I don't feel comfortable with this, doing Duncan Farms and then doing this a different way.
Yeah.
When the situations are identical.
Yeah, it's something that I expect, I certainly appreciate that we put the committee in a bit of a difficult position in these applications. I think this is going to evolve over probably the term of your over the duration of your term on the committee, and I think as we get into the new official plan, there will be some more discussions around that. So I'm hopeful we'll see some progress in the months ahead, but there may be some difficult decisions to be made in the interim.
Just a guess, but I still think it, based on what you were mentioning, proximity to water, still a pond, but maybe that's maybe what they're thinking, maybe triggered it, but again, I'm just guessing. And we're past that, yeah, but yeah, just a thought.
It's the administration's intent to continue working with our First Nations neighbors to try to receive site-specific comments that will help aid us in our decision-making. But it is very difficult when you receive a general letter that does not include that information.
Yeah.
And, just to simply say that it could impact all of these things, it makes it very difficult for us to make a recommendation on a site by site basis under these circumstances. So that's something that we're actively in communication about, but those issues have not been resolved at this point in time.
And there have been files that we've done archaeological.
Yeah.
Reviews and everything else too, so.
And typically, like the one on the Winnipeg River, that was something that was done was, we recommended the archaeological study be completed, and the applicant was more than happy to do that. And we facilitated a meeting with that First Nation and that applicant, and it went very well. So there were a lot of good news stories, but
In my mind, the difference is that was forested, untouched land.
that's right.
And
And
this
it's-
is clearly cleared land that had been in use in the past.
For 100 years,
Yeah,
like for a long time.
Yeah,
Probably closer to 150.
okay, well, let's move on. Good discussion, everybody. We're moving on to D 14-2310, the city of Kenora. The bylaw, the omnibus bill of bylaw changes. Kevon, are you going to speak to that one? I'm not sure how to
Yes.
proceed. It's a little different from my usual notes here, but Kevon, yeah, you take the lead here, please. Thanks.
Yeah, and this is something you don't see too often, but they do happen a little bit less frequently around Kenora than you would with large centers with more complex bylaws. So basically, what we're proposing are a series of amendments to address some issues that have been identified over the years since the zoning bylaw was originally adopted in 2015. And also there's a few of the amendments are in consideration of a council resolution from last spring. So the impetus behind the individual amendments varies to some are issues that were identified just through seeing the minor variances that have been required over the 8 years since the zoning bylaw was first adopted. Some came out of some of the early consultations we had in the ongoing official plan review from our technical advisory committee, and also what we hear from some designers and architects and developers who are particularly active in the community. So certainly I'm going to run through just sort of a summary of the proposed amendments, and certainly I'm open to I'll keep them brief, but certainly if there's anything that you have particular questions about, feel free to just sort of note that down and ask me after I'm done, and I can certainly delve into individual amendments to explain them if my summary is sort of glossing over them too quickly. So I'm just going to go through them in the order that I listed them in my report here. So first, we're making some changes to our definitions section. Basically, we're taking a bunch of different dwelling definitions and simplifying them down into 2 types of dwelling, either being a single detached dwelling or your single family home, and another definition for everything that's multiple units attached together, whether they're stacked side by side or on top of each other, or in duplex, triplex, fourplex, to simplify how we treat those multiple unit dwellings. And then secondly, we're adding a definition of a small home park, and which is I'll get into that in a bit. It's an additional use we're planning to incorporate into the existing RM, or residential mobile home park zone. The second part here, and this is one we were just talking about a couple of minutes ago, section 3.13.1. We've had a few issues with this one in the last year or so, in that it restricts to 1 dwelling per lot, and a dwelling being any number of units under 1 roof. So we're proposing that be amended so you can have, just like we saw with the white zoning amendment, situations where there are multiple individual buildings all on 1 lot as part of 1 development. We're proposing to remove section 3.13.4. This was just a peculiar little section of the zoning bylaw, probably carried forward from old zoning bylaws, but it didn't. It resulted in 2 sets of regulations for doing sort of the same thing under the zoning bylaw. So we're removing this one to simplify things for the rules in redeveloping properties. And then section 3.23 parking provisions, I'm proposing to standardize the number of parking spaces for all multiple unit dwellings. Previously, we had different calculations depending on the different type of multiple unit dwelling. First of all, for the number of parking spaces per unit, and then for visitor parking spaces. And then we're proposing amendment to the section regarding new uses in existing buildings in Harbour Town Center. To eliminate the need for loading and visitor parking spaces in the downtown area, and to reduce the parking requirement for uses to 1 per dwelling unit, 1 space per dwelling unit, and 50% of the normally required parking spaces for all other uses. That'll be a significant reduction, but just considering the fact that in our Harbour Town Center, we have quite a few parking options. There's a lot of on-street parking. There's a parkade, some big parking lots. So the need for meeting parking on site is less urgent than you encounter in other areas of the city. In the R1 zone, we're just simply proposing to allow for slightly smaller minimum dwelling sizes, so people can build smaller, more affordable homes. We're doing the same thing in the R2 zone, but we're also proposing in the R2 zone to increase the height allowable, or the permitted height, by 2 meters. And and then we're just changing around the references to dwellings to incorporate that multiple attached dwelling definition with a limit of 2 units. So it's equivalent to the current allowance for duplexes in that zone. Under the R3 zone, we're adopting a standard set of regulations. So previously, again, depending on which type of multi-unit dwelling, you had different sets of different requirements for setbacks, even lot width, lot area, building height. So we're proposing to adopt 1 set of standards. So it basically gives you, regardless of how you stack or rack up the dwellings, whether they're on top, behind, beside each other, as long as they fit into the same building envelope, they're fine. We're proposing to increase the permitted height to 16 meters, allowing significantly taller buildings in the R3 zone without requiring variances. And then changes just to match with the change in the definitions of the dwelling types. In the RM zone, as I mentioned earlier, we're proposing to allow a small home park. So just like you have a mobile home park of mobile homes and modular dwellings, you could have similar arrangements of small homes. So you could have a number of small homes in a park type setting with a sort of a central office or communal facilities, all on a single property. In rural residential zones, just a little bit of housekeeping. In our current bylaw, we have under the list of permitted uses, sleep cabins is listed as a permitted use. It's actually an accessory use. You can't have, and it's clarified elsewhere in the bylaw that you can't have a sleep cabin unless there's already a permitted use on the property. So we're just removing it from the permitted uses section to reduce any confusion there. Again, allowing for smaller dwelling sizes like we are in other residential zones. And then we're proposing a couple of changes that are specific to lots that are on Black Sturgeon Lake right now. There's 2 common residential zones on Black Sturgeon Lake, the RR and the BSL zone. In the BSL zone, you can only clear 25% of your frontage, and you need to have wider frontages. That was never implemented for the RR zone, so we're proposing to have the same requirement of RR zone, just so that any development on Black Sturgeon Lake is taking the same steps towards mitigating the potential for impacting water quality as a result of shoreline clearance and development. And then we're also in rural residential zone removing a minimum width requirement for modular homes. Up to this point, we've required a minimum width of 6 meters, but we didn't see that as serving a benefit to individuals wanting to put smaller modular or mobile homes onto properties. These are large properties, they're often buffered from the neighbors. It's not, we can't see any negative association with allowing that. Moving to commercial zones, doing a little bit of housekeeping here in terms of clarifying that dwelling units have to be accessory to a permitted use. So you can't just have a standalone apartment building. It's got to be, there's got to be a primary commercial or other permitted use in the in the, on the property with that. Increasing the maximum permitted building height, just like we did in the R3 zone or similar to it. We were in the initial application here, and I'll get back to this later. We were proposing to restrict clinics and offices from being located in the first story of a building. I've subsequently realized this seems to have come out of a miscommunication in an early meeting when we were discussing what we would do with the general commercial zone. I'm actually going to recommend that particular section not be recommended to council for approval. And we no longer feel that's necessary. We're slightly reducing the minimum gross floor area for dwelling units to allow slightly smaller dwelling units and line up with other minimum dwelling unit size for apartment type dwellings elsewhere in the bylaw. And removing a regulation that stipulated that that commercial uses on upper floors had to be an extension of a ground floor use. So up until this point, if you had a commercial activity going on the second, third, fourth story, it had to be an extension of a ground floor use. And we didn't see a continued benefit to allowing that or requiring that. So we had a zoning amendment last year for a medical clinic that wanted to be in the fourth floor of a building downtown. With this change, we wouldn't have to get variances to allow for those upper floor commercial developments anymore. Near the highway commercial zone, we're again increasing the allowable building height, and then a couple of restrictions or a couple changes related to dwelling units, clarifying that they have to be accessory to a commercial use, and removing a restriction that they had to be occupied by the business owner, caretaker, security guard, or similar employee. Basically the approach here is if you can put an accessory dwelling unit in, we're happy to see it, and we have no interest in controlling who lives in that dwelling unit after it's built. In the rural zone, we're proposing again to decrease the minimum permitted dwelling size and remove the minimum width requirements, same as we did in the rural residential zone for modular homes. And then finally, for the small home zone, so this is a zone that was introduced in 2018 to the zoning bylaw. It's never actually been applied to any property, so it exists as a zone you can apply to a property, but no one's been interested in it so far. So we're proposing to amend that, reducing the lot frontage area, setback requirements, floor area requirements, and increasing the permitted building height to give some more flexibility in the hopes that it will achieve its intended use, which is encouraging development of smaller lots with smaller homes that might be more affordable and meet a need in the city. So there was a site-specific amendment included in the proposal, just to exempt one property at the corner of First and Chipman from the changes to the general commercial zone. But those particular changes were the not permitting a clinic or office in the first story. If the committee removes that recommendation to council, or it doesn't support that part of the proposed amendment, then the site-specific zoning amendment would not be required anymore either, because there would be no need to exempt this property from regulations that are being implemented. So that's my quick run through of the proposed amendments. Now, just turning to the policies that all of our zoning amendments have to comply with. First of all, the provincial policy statement. I've referenced various policies from the PPS that encourage development within settlement areas, that encourage promotion of appropriate development standards, that encourage us to promote economic development and competitiveness, and also to provide for an appropriate range and mix of housing options. Taken in their entirety, these policies encourage zoning regulations that offer more flexibility in residential development, and which recognize the importance of promoting commercial uses in commercial areas with consideration to the value of mixed-use developments. Typically, that combines commercial uses with accessory residential units. PPS also does, as I noted in our previous report, require planning authorities to engage with Indigenous communities and consider their interests. In regards to the growth plan for Northern Ontario, we're satisfied the proposing zoning amendment is consistent with the policies of that plan. In terms of the City of Kenora official plan, I point to Principle 3, affordable housing, which sets out the objective of providing a mix and range of housing types to meet the physical and financial need of current and future residents. And Section 3.2B5, which states that the City of Kenora will encourage and promote the development of affordable housing by providing a toolkit of planning incentives, including more flexible zoning. And that's the provision of more flexible zoning is what most of these amendments are intended to accomplish. Section 4.3, Harbor Town Center. I note that it states in part that the Harbor Town Center is to contain major concentrations of a variety of uses and a dynamic commercial core. Multi-unit residential in conjunction with commercial uses is to be encouraged. With street level is to be used for commercial purposes. And 4.3.4 parking states that change in use in existing structures will not require the provision of additional parking. But conversions may be required to provide additional parking in accordance with the zoning bylaw. And parking spaces are not to be reduced unless the number of parking spaces exceeds the requirement of the new use. And then finally, Section 5.3, Black Sturgeon Lake Restricted Development Area. That section sets out policies for the protection of the lake, including policy 5.3.4A, which states the city shall restrict shoreline disturbance for any property in Black Sturgeon Lake to a maximum of 25% of the lot frontage. Now, in regards to the city's own zoning bylaw, which we're proposing to be amended here, there's various sections as you heard proposed for amendment. And all other sections of the bylaw, other than those that I've summarized, will remain unchanged. And yeah, I just know what I think I've covered my other comments there already. When he sent this out for interdepartmental and agency comments, we did hear back from Weshesh-Kanagan Nation on this one. The Weshesh-Kanagan acknowledged the importance of the proposal for amending our development processes, but note that the city should have endeavored to include them as part of the review process, not upon its completion. Their sacred law, the Manitoaki Nakagawan, must be recognized and observed as part of the review and approval process for them to properly engage with the changes being proposed. Being put in this position forces them to object to the proposed zoning amendment until they have conducted the required reviews and consultations. They note that Treaty 3 in Anishinaabe, they are guided and bound by this sacred law, which requires proponents to consult with their elders and knowledge keepers to identify potential impacts, require mitigation efforts, and establish appropriate ceremonial protocols. In addition to the requirements of the sacred law, the following questions have been raised, and they set out 4 questions here. Asking first, have the studies been undertaken to identify current and historical resource uses by the Anishinaabe at Kenora's Harbor Town Center? Please comment on uses pertaining specific to culturally significant sites, berry harvesting, and manoomin, including impacts to these uses and identify mitigation measures. 2, proposed changes to policy 3.13.1 identifies Black Sturgeon Lake as a restricted development area, but includes that accessory structures are permitted. How will the future development be permitted or monitored within this area if it's remain restricted? How are the proposed lot size restrictions developed? How are the impacts from development along Black Sturgeon Lake monitored and mitigated? 3, how will the proposed amendment and subsequent activities resulting from the proposed amendments impact their abilities and a capacity to exercise their Aboriginal and treaty rights to engage in traditional land uses? And 4, how does/can this zoning amendment process aim to respect processes under the Manitoaki and Nakagawan and application framework? They state that they believe the consultation on these matters to understand how the conduct communicated in their notification may impact their Aboriginal treaty rights, and if applicable, discuss ways in which the City of Kenora's and Grand Council Treaty 3's development approaches and processes may be harmonized to reasonably accommodate their Aboriginal and treaty rights, nation concerns, and interests. A decision by the City of Kenora to approve this application without consultation will be considered a violation of the Manitoaki and Nakagawan and our constitutionally protected rights. This was also reviewed internally. As a result of that review, it was determined that the proposed amendment, as I mentioned earlier, that would recommend clinics as offices, permitted uses in the first story of buildings in the DC zone is not reflective of the city's current vision for economic development, and removing this section of the proposed amendment would also remedy the need for the site-specific zoning amendment. Public comment, the public meeting, a statutory public meeting is scheduled for council on January 9th, 2024. Notice of the application was given in accordance with section 34 of the Planning Act. The notice also stated that the committee would have the opportunity to consider recommendations at this meeting, and the relevant resolution will be forwarded to council for their information. One comment has been received from the public. That comment requested a public open house and expressed concern regarding the proposal to restrict office and clinic uses from being located on the first story of buildings in the GC zone. I will note that the PAC meeting is the public open house. So finally, my evaluation, the proposed amendments in general are supported by the provincial policy statement, the growth plan for Northern Ontario, and the official plan. I anticipate that the proposed changes to regulations related to residential development will reduce the number of minor variances and zoning amendments that are required to facilitate future development and provide more flexibility for future residential development, including several that the department are anticipating will come forward in the near future. Many residential lots in the city are challenging to develop due to topography. Allowing taller buildings and reducing parking requirements for larger residential developments will make it easier to develop these properties by allowing buildings to be built narrower and taller with smaller parking lots. The new regulation will also enable properties zoned for high density development to be developed with multiple smaller dwellings that can make best use of buildable areas of the property. Minimum dwelling sizes are being reduced in all residential and rural zones to allow property owners to build smaller, more affordable homes, and to accommodate small home development. The RM zone is also being amended to allow for the small home parks. In the rural residential zones, proposed amendments will implement official plan policies that were intended to protect water quality on Black Sturgeon Lake. Proposed changes to the parking requirements in the Harbour Town Center, and to increase the maximum building height and allow commercial uses to be established in upper floors of buildings in the GC zone without having to be an extension of first story use, are expected to make it easier to redevelop existing downtown properties. Height limits are also being increased in the highway commercial zone to allow for taller developments such as hotels and office buildings in those areas. The proposed amendment that would be ever removed clinics and offices as permitted uses in the first stories in the GC zone has been determined, as I've noted, to be incompatible with the vision for economic development, and I am recommending that it be removed from the proposed amendments along with the related site-specific exemption. The planning department will be responding to the questions posed by Wajcik and Agam. As proposed amendments will not have the effect of approving new areas of development, we are confident in recommending that the proposed amendments proceed to council. So it's therefore my recommendation that the application for zoning bylaw amendment file number D14-23-10 to update various regulations of the bylaw should be recommended for approval to the city by City of Kenora Council. On the condition that the proposed amendments to remove clinics and offices as permitted uses in the first story of a building is removed from the list of proposed amendments, along with the associated site-specific amendment. I should have added that in there to my recommendation. So with that, I conclude my report, and I know I've covered a lot here. Certainly happy to answer any questions anyone might have.
Okay, thanks, Kavan. Well, since this is an open house, we haven't had anyone from the public to this point, but maybe there's someone out there who wants to comment.
There's no one, Mr. Chair.
Okay, all right, let's have a committee discussion. Oh, there's one other letter though that wasn't noted. Do you want to note that, Albert? There's one other comment that in the file.
Oh, yes, we received one public letter. It was addressed in the planning report.
Okay, I just missed that.
That's the two letters again.
So just, we really are looking for your input on these proposed changes at this point. We're not proposing that it go to council in January, but be deferred until February till we can get some additional information from staff and yourself, and if any changes are needed.
Well, let's go through, we'll skim through the 13 points, just go in order. And if we have any, we'll skip them if we don't have comments, but at least we'll kind of go through a logical order. And then Alex, you will be noting those comments and sharing them with council. Is that how this is gonna go, Jen? Okay, please, thank you very much. All right. What is number one here? Okay, definitions. Anybody got from the committee here have comments on section 2 definitions? Section 2, well, the second part, section 3.13.1 residential lot occupancy. Any comments on that one?
I just had a question on it.
Okay.
We're talking multi-building residential for the most part, but I was just thinking, if you've got a single residential lot in Kenora with a house on it, and it's big enough that you can put another house on it, would that not also fit into this category too?
Yes, it would.
So if you're there are changes that council considered at their last council meeting earlier in December regarding secondary dwelling units. And that's in keeping with the legislative changes that were enacted earlier this year about secondary dwelling units. And the definitions on attached dwelling units also fall into that. So within the urban areas, R1, R2, R3, you're allowed to have secondary dwellings, and one of which can be in a separate building. So
Okay, so that's not a change then.
so that's not a change. You can have one now, and that those sections of the zoning bylaw have been, if adopted by council tomorrow, then those will be spelled out very clearly, and that's a part of the reason during this amendment until February, because if council makes the changes they made that are proposed that they make tomorrow evening, then we want to make absolutely certain that the wording is together properly, but certainly that is the case in urban areas under the current legislation, and we can't override that. We're allowed to have a secondary dwelling in a detached building as long as it doesn't exceed the lot coverage.
Okay.
And then there's the legislation does not require that in rural areas. So we're also looking at allowing secondary dwellings in some rural areas, not the Black Sturgeon Lake restricted settlement area or restricted development area, but the other rural areas that you would be allowed to have a grandmother suite or that sort of thing.
Or a separate dwelling.
Separate. The separate dwelling would be restricted in size. Okay, so we're proposing a maximum size limit on that secondary dwelling, so it could not be more than approximately is 70 meters square, which is 750 feet, 2-bedroom. So it's fairly modest.
Anyone else on 313.1? Section 313.4 conversion of residential buildings. Any comments on that one? 0.3. Section 323 parking provisions. There's a few ABC. Any comments there?
Sorry, 323.
Just 323. There's no dot on that one. Parking provisions.
The only comment I had was on B. It said that you'd have 0.2 parking spaces for a lot containing 4 or more dwelling units. So if you have 4 dwelling units, that's 0.8 of a spot. So I assume that just has to be rounded up, or
Yes,
is that what's done? You just round it up?
yeah, we just round off to the nearest whole number.
Does that include the Harbortown Biz? I can't
I
remember.
think we're getting to that one.
I think that's separate.
Yeah.
Yeah, there's a whole other bunch on.
Yeah.
We'll get.
Yeah, there's a different rule then when you get to the Harbor Town. Yeah.
Okay, so 0.5, section 4.1 residential first density zone. is reducing the gross floor area to 70 meters squared.
Yeah, and that 70 square meters would be the new standard across all of our residential zones and rural zones.
Quick question, Kevon. Do you make these number choices with some analysis, or are you just shrinking it from 80 to allow for some modest improvement in or reduction in building costs?
It is an incremental change. So right now the standards is variously 80 or 90 square meters depending on the zone. So just allowing one standard and reducing that a bit. At 80 square meters, that works out to about 864 square feet. I know there's quite a few affordable housing packages that come in around 800 square feet.
Yeah.
That's pretty much a sort of traditional 60s
Pretty
bungalow.
standard modular. Yeah.
So getting down to 70 square meters gets us about 750 square feet or something like around.
So, so that's, other jurisdictions have similar square footage requirements, like we're not being the oddballs here, this is normal.
It's not.
I'd say this was the oh, sorry, somebody else talking.
I was just going to say, I did look into it to see what you could do with a 70 square meter dwelling, and like I said, it's on one level. Like if it's not a 2-level house, you can have a modest 2-bedroom home. So there is some debate on whether or not you actually need a minimum housing size. So relaxing it, as Kevin said, there are housing packages at that 800 square foot level that currently you would not be able to utilize with our restrictions. So bringing it down to 70 meters
Opens it up.
would let those modest housing packages that are available, look at home plan books, that would allow them to do that. And the question is, why would we stop someone from building something that's affordable for them? Because, you know, you'd have to recognize if you're building a small 2-story or 2-bedroom home, you won't have the same marketability as like for a 3-bedroom home. But if that's what you can afford, you don't need to say that that's appropriate.
Any other comments on that?
I think it also goes to a lot of the 50 by 150 lots that we have. Where again, a 70 square meter home can fit very easily on something like that. Where again, there's services at the road or the lane or whatever.
Yeah.
There's a lot of available real estate for that. Yeah.
Okay.
But again, having it at 80 puts you closer to like a 3-bedroom. You know what I mean? It's, yeah.
Good, all right. Point 6, section 4.2, residential second density zone R2. All right, so the same reduction from 80 to 70 in terms of the minimum. Yes, we also have a clause here to increase height to 12 meters. And the language on multiple attached dwellings. Any comments on that one? Section 4.3, the next one, third density zone, R3. Any comments on R3?
Just on B, we've always referred to 10 meters to 12 meters or whatever. I'm just wondering, buildings 16 meters from what was the old standard?
60 meters, the old standard was 10 meters.
Was it? Oh, so that's good.
It is quite a change. For some reason, all of our zones were 10 meter height, which is 2 stories. Well, they're 2 stories and ish. So
3 if you create a
right, so increasing in R3 when you're looking at multiple story apartment buildings, so 16 will, I believe, allow 4 story. Is that correct, Siobhan?
I can speak to this. 16 meters will allow for a modern 4-story structure.
A rule of thumb is it's about 3 meters a story. It depends on your framing methods, whether you're framing with steel or wood, and you know whether you're sandwiching your ventilation, you know, in between floors. So 3.5 meters is roughly 1 story.
Section 8, 4.4 residential mobile home zone. Any comments on that one? Small home.
Small home?
Well, it says mobile home is the official label, but this is where the small home part
So
comes in.
we do have. But it speaks specifically to traditional mobile homes. But, you know, a trend, I suppose, is to have mini homes in a park-like setting, like a mobile home park, and really. What is the difference other than, you know, the CSA standard that you can move a mobile home and a mini home might be constructed on site? So they're very similar, so why not treat them the same? And that's something that's done commonly in other zoning bylaws, instead of making a separate zone that's different for mini homes.
And there's more on small houses later.
Mhm.
Okay, interesting that the size restriction there is a maximum, not a minimum, 60. All right, number 9, section 4.5, rural residential zone. No, I'm not gonna read off all those amendments. Any comments on those? You've got the notes there. Anybody? No?
Had a thought about the previous one. What happens in between? I haven't thought it through yet. What happens in between 60 and 70? So if they're under 60, they're a small home. But then they're required to be 70 to be an accessory dwelling. Great.
Well, this is specific to a small home park, so this would only apply, you know, if somebody's setting up a development with a number of small homes on a single property. So if they're getting larger than 60 square meters, there's always the opportunity for variances, but the intention was to make sure that if we're making this type of accommodation, it is for truly small homes and
Gotcha.
Good.
Just the
Good.
varying public opinion on what's small nowadays.
Yeah.
you know, and
Yeah.
and there's always a chance that something might be proposed that's outside of what we're envisioning, and that's what variances are for. We're just trying to sort of envision the most common and likely scenario here.
Point 9, section 4.5, rural residential zone. Nothing more? 10, section 4.7, general commercial zone.
I did have a comment on C. And maybe this is not appropriate, but that was probably one of the best changes I saw, and now I'm hearing it's coming out. The reason is because I look at the city of Kenora official plan, and we talk about the Harbor Town Center being a dynamic commercial core of the city. And what we've got happening in downtown Kenora now is just offices. And our retail is disappearing. And I thought this was a way to protect that retail component. So it just doesn't turn into a, you know, Main Street is a main street of offices, and Second Street is a street of offices.
I don't know that we're proposing that it go away completely. We're proposing to take it out of this housekeeping bylaw so that we can do more fulsome consultation with our business owners. So I don't know that it'll come back exactly the way it is now, but we're looking to do more engagement with business owners and find out what makes more sense. We just feel that there hasn't been the fulsome consultation to bring it forward in this manner?
Well, even in the report, it says, Kevan says, I'm recommending that it be removed from the proposed amendments. Maybe let's throw in something so that we can have some further consultation or something. Because to me, this says, no, it's gonna be removed.
It is from this amendment, but it's not removed from the department's work plan. So it's still something that we're thinking about. We hear you and we're going to make note of that, and
Yeah, I would like that put in the minutes, by the way, that I am totally in support of something like this being included.
I am taking my planning hat off, as a member of the community. I agree with you, Robert. And I know as a planner that any current existing offices would be allowed to continue forward as legally non-conforming. So I don't necessarily see how this would negatively impact existing businesses. It would simply limit them from continuing to spring up in the Harbor Town Center.
Yeah,
But that doesn't change. You want your point noted?
I want my point noted.
Yeah, protecting retail development.
Yeah, commercial development to allow us to fulfill what we said in the city of Kenora plan.
And then by keeping it, then you would force whoever wants to have an office or a clinic to apply for a.
Yeah, I mean, you wouldn't kick them out,
Yeah,
but
they just have to
if-
go through the
if
variance.
somebody else wanted an office that again reduces retail. I mean. Our architectural controls, our controls of downtown. Trying to make it vibrant that's really bugged me for a long time.
Yeah, I like your side of the point. I mean, growing up in Kingston, I never understood why all the clinics, I had to walk upstairs and elevators, but
Yeah,
when you mention it from that perspective, keeping. Yes, all of the shops and retail and on the main floor. Yeah, just the opposite side of it, the accessibility side of it. Being a designer, yeah. Having clinics higher up, again, adds additional cost to construction, but. Yeah, so be it.
Did you get your question sorted?
No, actually, I need to request a very short bio break,
Oh, yeah. Let's take a pause.
because I want to get all your comments, I
Okay,
just, yeah.
And so we've got 3 minutes again. There's no need for a motion on this, right? This is just discussion.
Correct, yes.
oh, so we're just having discussion tonight then.
Yeah.
Okay. Then I should have been more forceful.
You still can be.
Yeah, nothing stopping you.
Well, you do, you're not making a decision, but you are making a recommendation to council. So again, we have that same flexibility as the last one.
Maybe just Alex isn't here, but the hotel that we approved way back in January was 18 meters. And I noticed that the sectional, it was the one we just did, number 10, right?
Highway commercial, yeah, so yeah, that was, the variance that was approved for that hotel was higher than what we're proposing under the highway commercial now. So they'd have to knock one floor off of that to be, but it's still, there'll still be a lot more flexibility than what we currently have for hotels and whatnot.
Yeah. Hotels are highway commercial? So we said.
Yeah, it's permitted use in general and highway commercial.
Okay. All right.
Is that the hotel on the Comfort Inn?
Yeah. I had to go back and check because I saw the 15 meters there. How tall was their request?
It was 18.1 or
18.2,
18.2, I think.
Certainly, we're not going to eliminate all variances, that's.
Right, yeah,
That is
exactly. You can't just make everything
You
like
can't
30
make
meters.
everything.
Yeah.
But
Sorry about that.
No problem.
don't you
Okay,
have something that's reasonable Well,
Yeah.
10 meters across the board is not a reasonable expectation.
Yeah. All right, moving on to section 4.8. This is number 11 on Kevin's list. Highway commercial zone. Any comments on that one? Point 12, section 4.12 rural zone. Finally, this is now point 13, section 4.21. Residential small home zone. So back to the old small homes. Any comments there? That brings us to the end of the list. Did everybody get to say what they wanted to say?
I just wanted to point out that this small home zone is different than mobile home zone with mini houses. This is small lot. So the homes on here would still be full-size dwellings, but it allows for smaller lots. So we have this section now. The lot areas were smaller, but for some reason the lot widths were not, which was seemed counterintuitive. It meant that you could have more shallow lots, but not narrower lots. And from the city's point of view, when you're talking about how much road you're maintaining and how much sewer and water and infrastructure, there was no savings to us because the lots were still just as wide as they were before. So what is the point of having squatter lots? You want sort of a little bit narrower. So going from 50-foot lots to a 40-foot lot.
Okay. Are there any areas in town with this?
Narrower?
Yeah.
I would say probably most of Rideout has narrower lots.
But no new
But
developments,
no new
right? Yeah.
development.
Not a lot of new developments anywhere.
So we do have an application that is looking for variance. You will be seeing that shortly to allow for 40-foot lots. Which had it been zone, small home zone, that would have worked for them as well.
40-foot lots is still wider than. That was Winnipeg.
There's
35.
some really narrow lots.
There's some incredibly narrow lots in
Yeah.
Winnipeg. I was also thinking of, in Selkirk, Manitoba, there's a street where all the houses are in these 20-foot lots and they're like those micro homes. And like, yeah, you could reach out, you could stand on your porch, go like this and touch your neighbor's wall. So.
Yeah.
There are certainly lots of examples. The old railway communities often had 25-foot lots. That was fairly common.
Mhm.
We're not proposing we go back to that narrow, but 40 gives us a little bit more flexibility to have more modest. Now, when I say they're more modest, you
Like 6,000 square five.
you could have compact development. You could have a house that's just as many square feet of living area, but on 2 stories instead of a bungalow, that sort of thing, which it is another housing option, which is what we're looking at, is encouraging housing options.
Good. Well, that brings us to the end of the list. And I think that's probably the end of the discussion on that. Secretary Treasurer. Any old business?
So
Do we not need to motion this?
Yes.
We do.
So having gone
That's
through.
recommendation.
You can make a recommendation to council what you're.
Or recommend, thank you.
Okay. So a motion to submit these recommendations to council? Okay, all right. Let's make a motion to submit these recommendations to council. Do I have a mover?
With the exception of C, 4.7, like the thing about the clinics and the offices, right?
You're removing that?
It is the administration's intent to remove that from this amendment at this time.
For further-
Your recommendation to council, you could make a recommendation to remove other things, or you could even recommend to keep that. It's,
So on to Robert's point that he made very clearly. Do you want your name on that? Because, so that'll be, I mean, we have our list of recommendations
Yeah.
or questions, but Robert wants his name on that one specifically.
Yep, got it.
Okay. That sound okay? And do people have, do we have a mover?
So we're moving this without that clause in there,
No,
Right.
we're just moving that we're submitting these recommendations.
but is that
Your
part of the
recommendation,
recommendation?
Yeah, that's what he's.
You're
Are you
recommending
recommending to leave
council's
them?
approval of the amendments as presented in the planning report. And you can say with or without the exception of the one that we're planning to take out.
Yes, that's what I would do,
Okay,
with further
Let's
consideration
specify.
and C or whatever it is.
So leaving C in.
No, Robert wants it removed, right? But we'd have to provide a motion, whether it's staying or going, correct?
No,
And then
Robert
we
wants
have
it
to vote
kept
on
in.
The recommendation from Kevon
Cause it says
was
now.
to
that
take
they're
it out.
gonna put That in there, and they wanna take it out.
So you're recommending to, if
Oh,
not meaning to put words in your mouth, but I'm going to. You're recommending to council that they approve the amendment as presented in the planning report. Do we agree on that part? And then you
Yes.
can have a second sentence that says with the removal of the office one, or you can just leave it at that. That would be your choice. Administration is going to remove it, but we will acknowledge the council. That you have recommended that it be there.
Yeah, I mean, I would recommend that. That it be there,
yeah.
so as presented in the report. Not, well, in the report though, it says that
The,
you wanna take it out,
Yeah,
so it's in one
or it
part.
should specify that we
But
want
if you
to,
look at the back at the recommendation is where it says,
Oh.
one of the difficulties with, keeping it in is we also have to do site specific one for the, development that's in process right now that we would not be allowed to go forward. If we change the zoning bylaw and changing the rules midstream.
what are the
Project is
current
that?
rules?
That's the one on the court, that's in his report.
Do you remember the WinHack clinic
Yeah.
on the mall site? It would be that property. Because
first shipment.
it's a clinic, 100%. So the first floor would violate the amendments that we're bringing forward here.
Albrecht.
Lisa, that's a question.
Oh, yes. Lisa, would you like to make a comment?
No.
Okay, my apologies. I just,
Okay. I just heard Albert.
yeah, I heard my name mentioned.
What is our motion? Can you read it back to us? Anybody got it?
Motion being. Recommendation is that, the updated various regulations of the bylaw should be recommended for approval by City of Kenora Council on the condition that the proposed amendments to remove clinics and offices as permitted uses in the first story of buildings is removed from the list of proposed amendments.
I like it all except for the last part. I mean, we approved that WinHack. project, did we not?
Yeah.
I think, for this purpose, you're making a recommendation. You can recommend.
They don't
that-
have to.
That all of the amendments as originally proposed be approved.
And just on that, Winhack, you did approve the variance there, but when they apply for a building permit, the building permit is evaluated at the time of application. So even though we proposed it under the current regulations with the variances a few months ago, and if we make these amendments, say if council had approved these amendments in January, and then they came and applied for their site plan control approval would be their next application. We would have, even though the variance made it okay under the current regulations, the new regulations would have had to be considered at the time of application. So that was the reason why we had to exempt it.
So we will be reposting this and putting a notice in the paper and then having a statutory public hearing for council. At that time, our report will be different than this report. If we take out that amendment and any others that administration chooses to bring forward, we will say that PAC had no concerns. We will not add anything that you haven't had a chance to review. We may take things out, and we will be able to say that you have reviewed them and recommended approval of everything that is being presented. So that's kind of how this is going to play out. I think we're quibbling over things that, like if you were recommending a different one that you wanted to take out, that would be, we would still go to council. We would say PAC reviewed this suite of things. They recommended we take this out, and administration did or did not. And then it would be council's decision, right? So what we're looking for from you is a recommendation of council. If you have any concerns with any of these, you should let us know. And that's.
So that brings us back to the motion, so it should say that we have a concern with removing.
So you're not voting on Kevin's recommendation. You're making a recommendation based on the amendments that were being proposed. So it's a weird situation where Kevin is put forward an amendment and then recommended that you taking away part of it. Well, he's doing that because we put it in the paper like this.
Yeah.
And then changed our mind and said, we're premature on that. We're going to be taking it out of the amendment. But you're not making recommendation on his, you don't have to use his words. You've read what's being proposed, you've read what's being advertised. If you have concerns with anything that's proposed or advertised, you should put that in your recommendation that it be taken out. If you're okay with everything, you can recommend that it be as circulated.
So I think that's what we're
Then that's what we can do.
doing.
That's what
As
you can,
presented.
that's what you can
Yeah.
do.
Okay.
Administration will consider that. This is your, and we will still, if we feel we haven't done enough wholesome engagement on that one point, we can still pull it, as we can pull out anything
Yeah.
else as well
Bring it back
and bring it back.
in the future.
Okay,
All right. This is a town hall
This is,
discussion, which is, there's not usually motions at the end of town halls. That's why I didn't think we needed a motion. But we do need a motion to say that we approve the
As
report as
circulated.
presented to us.
You're recommending.
We're recommending,
You could choose not to make a recommendation to council. That would be within your rights as well. Just you have the opportunity, and traditionally the committee has taken the opportunity to recommend approval or not, or or state any recommendations or concerns you may have.
We're approving the proposed amendments. We're not approving this report,
As presented.
Yeah,
That's right.
You're recommending.
You're recommending-
approval of the proposed
amendments,
okay,
and
good.
I'm good with that.
We move to recommend the proposed
As circulated.
that's circulated, okay.
But. Like,
So Jay, you're moving it?
no, wait, Albert made a motion, right? We all heard a motion. Right?
So do we need to defeat that motion?
You have to do
Robert's
something
rules?
with something, a motion on the table
I-
first,
I was merely reading out what
Right,
was
but-
written in the report.
but you asked,
Yeah,
so as a matter of order,
did we capture that first motion?
we would have to do something with that, would we not?
Yes,
Yeah,
you would read the motion, we'd have to move it,
So
second it,
there was
and
no-
defeat it,
There
or
was
if we
no
didn't like it.
mover on
Yeah.
that motion,
So it's dead on the floor.
so it's dead on the
No
floor.
mover on that first motion, dead on the floor.
Yeah.
So that should be noted.
Yep.
And then we have a new motion. Is that okay, Chris?
Yeah.
As circulated motion,
Yes,
which would be with the C.
So recommending approval of the amendments as circulated.
okay.
Yes.
Yeah.
All right, do I have a mover for that?
Okay,
Robert, seconder? Renee? All in favor?
Really?
Opposed? Chris is opposed.
yes.
okay,
I'm with the plan.
that's still carried.
Okay.
I'm with the plan.
Okay,
Okay.
old, now I can do the old business.
There is none,
None?
Mr. Chair.
New business is the new date, the Wednesday, not Tuesday now, is that what we're proposing?
Yes, that's correct. I'm just going to pull up my report for this.
Yeah, you sent those out.
This is to accommodate my schedule because council has changed. There was a conflict of Tuesdays and court days. So council is switching their meeting dates to Tuesdays so that court can use the council chambers on Wednesday. And I can't be here and in council at the same time.
So will we be 6 days ahead of council then? Like, are we going to be the Wednesday of the second week? Is council the Tuesday of the third week?
I believe so.
Yeah, council meetings do occasionally get moved around, bumped forward or back a week. So, which was why we felt we should avoid Tuesdays entirely, because even though council regularly is having committee of the whole on the second Tuesday and then the regular meeting, the third Tuesday, we have seen them move around before. So it's just cleaner to avoid Tuesdays entirely.
All right, yeah, fair enough. What's the next meeting date?
Okay, the 17th.
January 17th.
Yeah, and we have a couple of,
Right now, we'll be there.
I think we have 3 applications in, so there's definitely a meeting in January.
Is it in the boardroom or the training room?
Hopefully I'll.
Yes.
Yes. All right, that's a wrap. Any other new business? I guess we can't because it wasn't on the agenda. So I need a mover to adjourn, please. Robert. Good discussion, everybody. Thank you.
Did we move to change the meeting date?
Do we need to move? I thought you didn't hold us that it was the date.
Oh, we told you, but we need you to move and vote on it.
Okay, all right, would somebody please, oh, the motion is that. So the standard meeting date will be the third Wednesday of the month.
So the new meeting date will be the third Wednesday of every month.
What you said.
Okay, all right. So I move that the new meeting dates be the third Wednesday of every month, starting with January 17th, 2024.
Okay.
Mover. Renee, seconder,
Chris.
Chris, all in favor? Good, okay, now Robert also moved to adjourn.
Yep.
Oh, yes.
8:58.
Thank you, everyone.
All right.
Yes, thank you.
All right, thank you very much. Thank you for members of the public for joining us. The Planning Advisory Committee meeting has now concluded for this day.